But what if I told you that giving them your physical license could actually put you in a legally vulnerable position that most people don't realize until it's too late? I'm Sarah, and I've been practicing criminal defense and civil rights law for over 15 years. In that time, I've seen hundreds of cases where a simple traffic stop turned into something much more serious, all because people didn't understand what happens the moment they hand over that plastic card. Today, I'm going to break down exactly what happens when you give up your physical license, show you real Supreme Court cases that protect your rights, and give you the exact strategy to use instead. And if you stick around till the end, I'll give you the word-for-word phrase you need to use if an officer refuses to return your ID. Let's get into it. Here's what typically happens during a traffic stop. The officer walks up to your window, asks for your license and registration, you hand it over without thinking twice. Seems completely normal, right? But here's the legal issue that most people miss. The moment you hand over your physical driver's license, you've just lost your legal ability to leave that location. Think about it for a second. In all 50 states, it's illegal to operate a motor vehicle without your physical license in your possession. So when that officer walks back to their patrol car with your ID in their hand, you are legally stuck there. You cannot drive away even if you wanted to. And I'm not talking about fleeing, which is obviously illegal. I'm talking about your basic freedom of movement. The officer now has complete control over when this interaction ends, not you. And according to the Fourth Amendment of the United States Constitution, that's exactly where things can get problematic. You've essentially handed over a critical piece of leverage without even realizing it. And in my 15 years of practice, I've seen this dynamic used in ways that push the boundaries of constitutional rights. Let me tell you about a case that fundamentally changed how traffic stops work in this country. It's called Rodriguez versus United States, decided by the Supreme Court in 2015. Here's what happened. A man named Dennis Rodriguez was driving on a Nebraska highway one night in March 2012. Around midnight, Officer Morgan Struble noticed Rodriguez's vehicle briefly swerve onto the shoulder of the road, a minor traffic violation. Officer Struble pulled Rodriguez over. He asked for Rodriguez's license, registration, and proof of insurance. He checked his documents, ran a warrant check, issued him a written warning for the traffic violation, and returned all of his documents. At this point, the traffic stop was legally complete. But here's where it gets interesting. After completing everything related to the traffic stop, Officer Struble asked Rodriguez for permission to walk a drug detection dog around the vehicle. Rodriguez refused to give consent, which was his constitutional right. Despite this refusal, Officer Struble told Rodriguez to turn off his car, exit the vehicle, and wait. Struble called for backup, and when a second officer arrived several minutes later, Struble retrieved his drug dog and walked it around Rodriguez's car. The dog alerted to the presence of drugs. They searched the vehicle and found methamphetamine. Here's the critical detail. 7 to 8 minutes elapsed from the time Officer Struble issued the written warning until the dog alerted to drugs. Just 7 to 8 minutes. Rodriguez was charged with drug possession. His attorney filed a motion arguing that the extended detention violated the Fourth Amendment. The lower courts denied his motion, saying 7 to 8 minutes was a de minimis, meaning minimal, intrusion on Rodriguez's liberty. But the Supreme Court disagreed. In a 6-3 decision written by Justice Ruth Bader Ginsburg, the court ruled that a police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures. Justice Ginsburg wrote, "The tolerable duration of police inquiries in the traffic stop context is determined by the seizure's mission to address the traffic violation that warranted the stop." This wasn't just about Rodriguez. This case established a nationwide precedent that protects every single driver in America. Now let's talk about why some officers prefer to hold onto your physical ID during the stop. And I want to be clear that I'm not saying this is always intentional misconduct, but there is a psychological and tactical component that we need to acknowledge. From a legitimate law enforcement standpoint, yes, officers need to run your information to check for outstanding warrants, verify your license status, and document the stop. That's completely legal and appropriate. But there's also a psychological element. When an officer has your physical license in their possession, you are statistically more likely to remain compliant and answer questions that you are not legally required to answer. Questions like, where are you coming from? Where are you going? Do you have anything illegal in the car? You don't have to answer these. You're also more likely to consent to searches that you can legally refuse. The Fourth Amendment protects you against unreasonable searches, but many people give consent because they feel trapped and just want to get their ID back and leave. And you're more likely to wait for extended periods of time, even when the stop is taking longer than it should be under Rodriguez. I've personally handled cases where officers held someone's ID for 20, 30, even 45 minutes during what should have been a routine traffic stop. The driver felt like they couldn't leave, couldn't ask questions, couldn't do anything but sit there and wait. And technically, they were right to feel that way. Without that physical license, driving away would create an additional legal problem, driving without a license in possession. This creates what we call a coercive environment, even if the officer isn't being overtly threatening. So here's the practical solution that more and more attorneys are recommending to their clients. As of 2025, multiple states now recognize digital driver's licenses as legally valid forms of identification. States like Arizona, Colorado, Louisiana, Maryland, Mississippi, Missouri, New York, Ohio, Utah, and several others have official mobile ID apps. These digital licenses have the exact same legal validity as your plastic card. In Arizona, for example, over 1 million residents, about 20% of eligible drivers, are now using the state's mobile ID app. The adoption rate shows people understand the value. Now, if your state doesn't offer digital IDs yet, here's what I recommend to my clients. When the officer asks for your license and registration, you can politely ask, "Officer, am I being detained or am I free to go?" If they say you're detained for a traffic violation, that's fine. You're legally required to provide your documents at that point. Hand them over. But here's what you should also say, and write this down. I'm providing my license as required. For my own records, approximately how long do you expect this stop will take? This does two critical things legally. One, it creates a timestamp on the interaction, which can be important if the stop extends unreasonably and you later need to file a complaint or challenge evidence. Two, it politely but firmly reminds the officer that you're aware of your rights under Rodriguez versus United States, that traffic stops have constitutional time limitations. You're not being confrontational, you're not refusing lawful orders, you're simply being an informed citizen who understands their constitutional protections. Let me walk you through some real scenarios from my practice where maintaining control of your ID, or at least being aware of these rights, made all the difference. A client of mine was stopped for a broken taillight. The officer took his license, went back to his patrol car, and then came back and started asking completely unrelated questions. Where are you coming from tonight? Have you been drinking? Do you have any weapons or drugs in the car? My client felt obligated to answer because his license was being held. He answered all the questions, which led to the officer asking to search the vehicle. He consented because he felt trapped. Here's the thing. After the officer checked his license and registration, which took maybe 3 minutes, the stop should have been over under Rodriguez. Those additional questions were not part of the mission of the traffic stop. My client had every right to politely say, "Am I free to go?" Another client was pulled over for speeding. The officer took her license and told her to wait. 15 minutes passed, then 20. She could see the officer in his car, but he wasn't writing a ticket, wasn't running her license, he was just sitting there. When she politely asked what was happening, the officer said he was waiting for backup, but wouldn't explain why. Eventually, a canine unit arrived. They wanted to walk a drug dog around her car. This is a textbook Rodriguez violation. Unless that officer had specific, articulable, reasonable suspicion of a crime beyond the speeding violation, he had no legal authority to extend that stop to wait for a drug dog. We filed a motion to suppress, and the judge agreed. The stop was unlawfully extended. I had another client who was stopped for an expired registration sticker. The officer took his ID and, after running his information, started questioning him about where he worked, who else had access to his vehicle, whether he'd loaned the car to anyone recently. 25 minutes into the stop, my client asked, "Am I being detained for something other than the registration issue?" The officer couldn't articulate any additional reasonable suspicion. We successfully argued that the prolonged detention violated his Fourth Amendment rights. In each of these cases, the fact that the officer physically held the license created a psychological pressure that made my clients feel like they had no choice but to comply with requests they could have legally refused. Now, here's the situation nobody wants to be in. You've handed over your physical license, you believe the stop should be over based on Rodriguez, but the officer is not giving your ID back. First, let me be clear about this. Do not physically try to take your ID back. Do not raise your voice. Do not become confrontational. Your physical safety is more important than winning a legal argument on the side of the road. Here's the exact phrase I tell my clients to use, and you should memorize this. Officer, I've complied with all your requests and provided all necessary documentation. Am I being detained for a specific violation or suspicion of a crime, or am I free to go? If I'm free to go, I need my license back to legally operate my vehicle. Read that again. Notice what it does. It acknowledges your compliance, it asks a direct legal question about detention, it references your need for the license to drive legally, and it's calm, respectful, and non-confrontational. If the officer says you're still being detained, you can ask, "Can you tell me what specific violation or reasonable suspicion justifies the continued detention?" They are legally required to have articulable reasons. A hunch is not enough under the law. If they continue to hold your ID without providing a legal justification, here's what you do. Comply in the moment, do not escalate. Note the time, look at your watch or phone, and mentally note how long the stop has lasted. Get the officer's name and badge number if it's not already visible. If there are witnesses or passengers, have them know what's happening. If you have a dash cam or can safely access your phone to record audio, do so. In most states, you have the right to record police interactions in public. After the interaction is over, document everything while it's fresh. What time you were stopped, what time your documents were returned, what questions were asked, what reasons were given for any delays. Then, contact an attorney who specializes in civil rights or criminal defense. Unlawful detention is a violation of your Fourth Amendment rights, and you may have grounds for a civil rights lawsuit under 42 U.S.C. Section 1983, or grounds to suppress any evidence obtained during the unlawful portion of the stop. Listen. I want to be very clear about something because this is important. The vast majority of police officers are professionals who are doing a difficult job and trying to keep our community safe. This is not about being anti-police. This is not about making officers' jobs harder. This is about understanding the constitutional framework that governs police-citizen interactions. The law is designed with checks and balances for a reason. Officers have the authority to enforce traffic laws, investigate crimes, and ensure public safety. That's legitimate and necessary. But citizens also have constitutional protections under the Fourth Amendment against unreasonable searches and seizures. And the Supreme Court, in cases like Rodriguez, has made it clear that those protections include time limits on traffic stops. When you hand over your physical ID without understanding the legal implications, you're unknowingly tipping that balance of power. Digital IDs, polite but informed questions about detention, and awareness of Supreme Court precedent like Rodriguez, these are tools that help maintain the constitutional balance between law enforcement authority and individual liberty. You can be respectful and informed. You can comply with lawful orders and assert your rights. These things are not mutually exclusive. In fact, in my experience, calmly asserting your rights often leads to better outcomes than either blind compliance or hostile confrontation.
Will you focus on upgrading your